Another question I'm frequently asked about is wrongful termination. The Connecticut General Statutes provide that an employer cannot fire you or otherwise discriminate against you at the workplace as a result of your having filed a workers' compensation claim. That doesn't mean they can't fire you or lay you off after you have alleged a work-related claim. The employer just has to show that they have a legitimate business purpose for having terminated you. That could be because you had a bad record before you were injured, and then you did something subsequently that was the final straw. It could just be because they are eliminating your position. It can be for any legitimate business purpose. They can't fire you as a result of your having filed the workers' compensation claim. They can't discriminate against you for having filed the workers' comp claim. But if you can't go back and do your job, unless you have some type of a negotiated contract, Connecticut is an at-will state, and they can fire you for any reason at all, as long as it's not an unlawful reason. These cases, wrongful termination cases, are also known as 31-290A claims, and they're very difficult claims to prove. I should note that you have the option of bringing a claim in workers' compensation forum, or you can bring a wrongful termination claim in the civil court. If you're bringing it on the civil side, it's more expensive because you got to have a state marshal serve the complaint, and you have to pay the filing fees, and that can easily get up to $500 or $600 just for those two things. However, the other thing to consider is that your remedies in the civil side are better in terms of being able to collect punitive damages in a civil case that you can't collect in the workers' compensation forum. In order to take these cases, and I am very judicious in the cases that I take because they're very difficult to prove, I look to see how long the employer has worked for, how long you, the employee, have worked for your employer. The longer the period of time, the better a case you have, in my estimation. What your previous evaluations are at work, whether you had any verbal or written warnings that are documented in the file, and what the proximity is between the date of the injury and the date of the treatment, and the date of the termination. The closer those two are, the more likely that that there was something that was not correct in your firing, and that you could prove a violation of 31-290A. Thank you.